Welcome to all of you to the CBC building, and once a year we get the opportunity for you to ask questions about the criminal justice system, and you're lucky to get an opportunity to ask it of senior judges here in British Columbia. We have the 3 levels of courts in British Columbia that are here and are represented, and we have Madam Justice Mary Saunders from the BC Court of Appeal, which is the top tier of the courts in British Columbia, and I will ask her to begin by saying a little bit about herself and what her court does.
Thank you, Mr. Hanomansing. Well, and thank you everybody for being here today. I am on the British Columbia Court of Appeal. I'm also on the the Yukon Court of Appeal. Our court sits as the appellate court in the Yukon. We have 15 judges, and we have full-time judges, and we have 10 part-time judges we call supernumerary, which sit half-time. After they've done a lot of service, they're allowed to elect to go supernumerary. So that gives us a pretty large complement when we're full. Right now we are 4 judges short. We have vacancies, so we are only 11 full-time judges. My Chief Justice, who would like to be here today, alas, is overseas, so he could not be here, so I'm here in his stead. We are a court of error. That means that we look for mistakes that have been made. We look for mistakes that have been made by trial judges in their handling of the cases and by administrative tribunals. We don't hear evidence. We just look at the law and determine whether what happened was within a range of correctness or reasonableness. And if it is, we say no appeal. The appeal's not allowed. And if there is a mistake, we allow the appeal, or perhaps we send it back for another hearing. That's essentially our job. I've been on the court for 18 years. It's a very long time, and before that I was a trial judge, which was a wonderful job. I was a trial judge on the British Columbia Supreme Court, and I'm going to pass it over to the Chief Justice of that court now, Chief Justice Hinkson.
Thank you, and thanks to all of you for coming as well. The court that I'm presently in is a court notionally of 91 judges, and we have supernumerary judges as well. I've been at some pains to try and get our court filled. The present federal government has left us presently with 11 vacancies. We'll see more as the months unfold, and we haven't seen any appointments recently, so we're struggling with fewer judges than are thought appropriate for British Columbia, for our court. Our court hears all kinds of cases with the exception of piracy on the high seas and a couple of other novel kinds of cases that go to the federal court. We are the senior trial court in the province, so we hear some appeals as well from administrative tribunals and from the provincial court. This past year we had 70,000 new cases filed in our court, and so when I mention the number of judges we have, you can imagine how hard the judges are working to try and meet the needs of the public. We don't get all our cases heard within the same year. Sometimes it takes a number of years for cases to work their way through the system. We do predominantly civil work in our court. There were about 60,000 civil filings last year. There were about 12,000 family case filings and only about 1,500 criminal cases, because most of those cases originate in the provincial court, which is presided over by Chief Judge Crabtree, who's now going to tell you about his court.
Thank you. And again, I extend my appreciation for each one of you taking the time to come and spend with us for the next hour. So as Chief Justice Hinkson said, I'm the Chief Judge of the Provincial Court. The Provincial Court sits in about 80 plus locations around the province. So those of you that are in the lower mainland will know that our courts here in this area are at Main Street and at Robson Square. But we also sit in small isolated communities where a court team, including a judge and the lawyers and the court staff, would fly in. So for example, Bella Coola is where a court team would go in 3 or 4 times a year, and we'd hear cases there. So we don't have courthouses in those locations, but we use existing resources in the community. So for example, in Bella Coola, we're in the local community hall. And so when we're there for the week, the tables are put up and court is held in that facility. Usually attracts a huge amount of attention, so a large number of the local community will come and observe, not just those that have matters in the court, but those that are interested and have heard about the proceedings. So that's the number of locations we have. We have approximately 125 judges currently on our court, which is made up of full-time judges and judges which sit a reduced schedule because they are on a senior judges program. They're experienced judges that have elected to sit part-time. Our court hears different types of matters. The majority of the matters are criminal, so about 53% or so are criminal cases. And we also hear cases in civil disputes, family law disputes, and also child protection. Child protection is those files where the state has stepped in and removed or apprehended the child from the family, and we're called upon to determine whether or not that initial removal of the child was based upon the legislation that we are guided by, and if they were removed, whether they should continue to be removed or whether they should be returned with terms and conditions. While I wouldn't I wouldn't say one type of work is perhaps the most important, I would say, because of the fact that child protection and family law involves children, that's a very significant and important part of the work, particularly when you're dealing with removing children, at, which often can be a very young age. In one final point, just on our criminal jurisdiction, and I told you there's about 53% or so it's about, to give you an idea, about 70,000, 65 to 70,000 new cases a year. Most of those go through the process. A large number of those cases result in the person who's charged acknowledging responsibility, and as a result entering pleas of guilty to some or all of the matters that they're charged with. And as a result, our judges are involved to a large extent in terms of sentencing individuals, and that brings into play the provisions of the criminal code, and we can talk about that later on.
All right, well, thanks to all of you. Now, as you're listening to all of this, it may sound like it's kind of complex, because I suppose it is. So you have these 3 levels of court. You have the Provincial Court of British Columbia. You have the BC Supreme Court, which before I moved out here from back east, I thought that was the highest court in the province. But then we have the BC Court of Appeal, which is 1 layer above that. And then you heard reference to the Federal Court, which is a separate court system. You don't have to remember all of that today. Maybe you do for your Law 11 test. Is it 11 or Law 12? Anyway, you may need it for that. You don't need it today. You don't need to worry about asking a question that maybe was already answered earlier on by one of the judges. I mean, feel comfortable to stand up and ask whatever question you want. And this is your opportunity to get answers from people who are obviously very much involved in the system.
So I'm from Ideal Mini School. And I was wondering how well minorities are represented within the system.
And do you mean, when you say how well are minorities represented within the system, do you mean in terms of judges or lawyers or both, or what?
Both.
Yeah. Madam Justice Saunders?
Well, I'll take the first crack at that. We have more members from minority groups represented in the legal profession and on the courts. But I think we would all agree that we would like to see a larger representation. To be a judge, you have to have practiced law for a period of time. So that is one of the clogs that's between having people come into the legal profession and then having broad representation on the courts, you have to wait until enough people have enough experience that they can show that they are the sort of people, whatever that is, the sort of people that you want sitting on the bench that have the right attributes or thought to be the right attributes. The legal profession seems to me to be becoming more diverse. I go to the call ceremonies and I am always struck these days by how different the face is of the group of young people being called to the bar than was the case when I went to law school. My class was 10% women, and there were hardly any people, a few, just a handful, that were not Caucasian. The first big push to diversify was to put women into positions, I think, and that actually was putting some of the majority into positions because women are the majority in the community. And now, having achieved some representation, people are looking further and trying to expand that diversity, but it hasn't happened yet.
It is interesting how things have changed over time, and it's hard, obviously, for you to imagine this given your ages, but you were saying when you were at law school, 10% of the class were women. I graduated from law school 31 years ago now. It was about 50% women at that point, and I'll bet you it's more than 50%. I don't know if you guys have been to any of the law schools lately, but it's probably around 55 right now. Of women. So I'll get to the next question in a sec, but what have you seen change in terms of the representation of women among the judges?
We are more. On my court, we have actually had moments when we were more than 50% of the full-time complement of judges. So our court is quite well represented. The Superior Court, trial court, is less well represented, but still quite handsomely compared to historical terms. But 30%, 25%?
Well, it's closer to 50%
Is it now?
of the full-time judges.
Yeah, okay.
So we're getting close.
Yeah. And also I think the Provincial Court has a great many more women, and I think must be getting closer to the 50%, if not already there. So that's been a big move. I was only the 13th woman appointed to a Superior Court in British Columbia. That's a long time ago now. Yeah.
Chief Judge Crabtree?
So on our court, currently there's 40% women and 60% men on the court. I think that over the past 41 appointments, so our appointments are made by the provincial government to the provincial court. I can tell you that of that 41, 20 were women and 21 were men. So there's been a slow shift over the last 3 or 4 years to increase the percentage or representation of women on our court. But in addition, in terms, our court has become more diverse in terms of other communities, so it reflects more the face of the entire community. There are 5 Indigenous judges. And there are a number of judges from other communities, so that it is more representative of the entire community here in British Columbia than it certainly was 10 or 15 years ago.
All right, thank you very much. Great question. And next question, please.
Hi, I'm also from Ideal Mini. I was wondering, do you think there are any failures in the judicial system? And if so, what are they? And how could they be improved?
Well, that's a big question. It's a great question. Are there any failures in the judicial system? If there are, how can they be improved? I mean, you can sort of take any piece of that if you want. Like, I'm thinking if someone were to ask me that question about what I do, clearly there are things we do, I don't know if I'd call them failures, but certainly where we fall short of where we'd like to be. But there's so many things I could address. But Chief Judge Crabtree, let me begin with you. Is there anything within, not so much in terms of failures, but in terms of maybe what's at or near the top of your priorities as Chief Judge in terms of something that your court, you feel, needs to address?
Well, I think that there's a number of opportunities where we can build upon a solid foundation and we can improve. And so one of the areas I think where we're spending some attention, first of all, is in trying to engage in enhanced technology to enable that to provide a more accessible justice system.
So could you give me an example
Sure.
of what you mean?
So the example on our court and many courts are trying to engage video appearances in a more pronounced way so that it creates greater access. And I'll give you an example. So in our court, I told you that there are 80 plus locations around the province. You know how large geographically the province is, and it's difficult for individuals to appear in court locations and to have judges available. So we have arranged where hearings can be conducted where appropriate by video. Often that's court applications or bail applications to provide greater accessibility, linking individuals to a judge to have the matter dealt with in a timely way. There's other aspects to technology which I think that can be engaged. The way in which we communicate, just in getting information out to individuals. Our court has spent the last couple of years trying to improve our communication with the public by way of redoing the website, for example. By writing articles which you can sign up or subscribe to, which you'll receive automatically and electronically, which you can then read about what's happening about the court. So creating greater accessibility to each of you through the use of technology is one area which I think we can improve upon.
Accessibility, technology, you're making eye contact with me as a TV reporter. I can't help but wonder about when we'll see television access to courtrooms in a more prevalent way than we do now. But we'll save that question for later because we have a lot of people here, and we'll see what other students have to say.
Hello, my name is Rosetta Peck, and I'm also from Fraser Heights Secondary School. So I was reading over the CJC's ethical principles of judges and came upon a clause that said the objective conditions and guarantees include, for example, security of tenure, security of remuneration, and immunity of civil liability for judicial acts. However, if a judge consistently makes errors in their convictions and a high number of their cases are overturned, therefore subjecting innocent people to suffer for a longer period, how does the Canadian judicial system deal with him or her, since judges are not allowed to be fired or held liable?
So let me ask you a question. How do you feel judges should be dealt with if they make a decision that's incorrect?
Well, I feel that they first should go into a review of all their cases at first and see if there is bias there, and they should be removed from the bench.
And do you feel that that's happening, that there are decisions that are made incorrectly because of bias?
Yes, I believe so, especially since Aboriginal people are being held accountable more than any other race in Canada. Also, as well as there was a case in which a judge said to a woman who was sexually assaulted to, quote unquote, keep her legs shut. I believe that was also raging from bias as well. So. And
you know, in that case, what happened to the judge? Like he's no longer a judge, right? Like
yeah.
that case. And so the reason, I'm not trying to challenge you. I think it's good in this setting to, kind of get a bit better sense of the question. I have to say, I'm not a lawyer, obviously not a judge. I have spent a lot of time covering the courts. I'm very critical of certain things I've seen in the court, but I have to say, especially over the 25 years or so, or more than 25 years that I've been a reporter, I have seen, especially in the last, I would say, 20 years or so, I have seen judges almost without exception be diligent. I have not seen examples of judges being racist or sexist, particularly in the last 20 years. I find the system actually works very well, and then if judges make mistakes, and first of all, mistakes is a subjective term, right? Some of it may be the human failings we all have. Some of it may be a disagreement about how the law is applied. Then you have the various levels of court that are, the appeal courts who will deal with that. But let's get back to the beginning of your excellent question, which is this notion that if judges make mistakes, or let me put it a different way, that I think she's asking whether judges are not accountable for their mistakes since they can't be removed from the bench very easily.
Well, maybe I can take that one on. The Judicial Council of Canada consists of each of the Chief Justices from the various courts. There are 39 of us, and the quote you've offered is from the material that we create. In the United States, there are a number of jurisdictions where judges are elected, and what you find shortly before elections is that the criminal sentences tend to go up because the vote is thought to be a law and order vote, and so if you get convicted early in the judge's tenure, you'll get a lighter sentence for the same thing that you would get later on. Those of us in this country think that the election of judges is probably not the correct way to see judges join the courts. And so we have a system where judges are appointed, and some rigor is attached to the appointment process. There are investigations at various levels to try and assess who's suitable and who's not, because not everybody who applies, in fact in this province only about a third of the people who apply are appointed. But once you're appointed, the thinking is that you should be shielded from attack unless you're doing something that's so beyond the pale that you're not qualified to sit as a judge any longer, and that's what happened with Justice Camp. At least that was the recommendation. He resigned. You probably know as well that the fellow that he acquitted initially was acquitted on the retrial, and so found not to have been guilty of the sexual offense. But when we do what we do as judges, if we had to worry about our incomes or our job, you're going to find that the senior lawyers are going to be less likely to want the job, because you do sacrifice going to the courts. Most senior lawyers make more than judges, and so you sacrifice your income. You sacrifice a lot of your independence because you're scrutinized each step you take. And it's important when you ask people to make those sacrifices that you say to them, look, we're going to accept you're going to make the odd mistake. In this province, in the Court of Appeal, Chief Justice Bowman sets the rotas. In the Supreme Court, I set the rotas, and I decide which judges are going to hear which cases. And we have judges who come from all different backgrounds. We have some who come from the family bar, for example. They're not going to be as experienced on criminal cases as someone who came from that area. But we're all expected to do each kind of case that comes before the court, partly because we sit throughout the province, and you can't have the expert in one area traveling around the province and the other judges not participating in that kind of thing. So there's a number of factors that go into the protections that we enjoy and expect, and those are some of them. I can't begin to tell you about all of them.
Just before that, I have a question. If you read through appeal decisions, you will often see where appeal courts will say that the trial judge has made a mistake. And I'm curious, at the trial level, how does that affect judges when a provincial court judge is waiting for the Court of Appeal decision to come down, and the Court of Appeal says that he or she made a mistake? What kind of impact does that have on them?
Well, I've sat at both levels of court. I sat in the Court of Appeal for a while, and I found it more unpleasant telling my friends and colleagues that they made a mistake than I found it being told I made a mistake. I think that happened once. I was told I made a mistake.
But you know, I mean, people.
It was Justice Saunders who told me.
People who are here, I'll bet some of them at least look at that and say, you know, you guys are a club of, you know, former lawyers. Now you're judges. You go to the same restaurants. You go to the same events afterwards. Are you really critical? Are you really? It would be so easy not to be critical in these appeal decisions. How do you deal with that when you're, you know, these are colleagues of yours?
You know, it's just your job. You get used to doing it. we have about the same percentage of appeals that come to us allowed year after year after year. We have the statistics, and I think it's somewhere between 35 and 40% of appeals that are allowed. It is less than half of the cases where somebody thinks something's gone wrong, they come to us. More than half of the times we say, no, the judge got it right. We are not a trial court, so all the findings of fact and things like that have to be done by the trial judge, by the provincial court judges and by the Supreme Court judges. But it's just not hard. It's a hard thing to explain. You just get used to doing it. It's what your job is. You analyze it, and there's the answer. And sometimes you think, ooh. Sometimes you try and say it with some care so that you're not too wounding about how it happens, but you do what you do because it's your job. We've taken an oath. And I will say that the oath of office that we have all taken is very, very important. People hardly ever talk about it in public, but we've all taken an oath, and we're all serious kind of people. We're all a little bit nerdy. I'm sorry,
Particularly Judge Crabtree.
Do you see how I look fast? But we're serious people, and so we've taken the oath, and that's our job. That's what we're getting paid to do. Yeah.
Nerdy Chief Judge Crabtree?
Thank you. I just wanted to return to the question because Chief Justice Hinkson outlined the importance of judicial independence, and that is to ensure that you have someone who's completely independent making the decision. But with that independence comes a significant obligation, and you made reference, I think, certainly to the Canadian Judicial Council, and they've published a series of ethical principles which sets the guidelines for judges. And one of the most important parts of that guideline is our duty to ensure that we stay current with the law and continue with judicial education. Chief Justice McLaughlin, in her tenure as Chief Justice of the Supreme Court of Canada, has been very supportive, and I would of judicial education, and setting a very high standard in terms of the ongoing obligation that each of us have each and every year. So we have fairly significant education programs both in each of our courts, but also programs that are offered nationally to all judges so that we can continue to learn, continue to improve our skills, and to continue to ensure that we're current in the law.
Do you have a follow-up question?
Yeah, one more. So, as human beings, we are not infallible to bias decisions, and as judges, what do you do to ensure a fair trial?
In terms of, because we all have personal biases. So yeah, we all come to the table with our lifetime of experiences and our biases and our feelings. So how, let's say particularly at the trial level, so maybe Chief Judge Crabtree, how do you deal with personal biases when you're hearing a case?
Well, I think that there's a distinction to be made between thoughts that I may hold and predisposition to a particular case. So what I see as a large part of my role, and partly through education, is to ensure that, first of all, that I don't bring any predisposition to a particular case. I come in, despite what my personal view or opinion might be, my role, having taken the oath that Justice Saunders just referred to, is to go in and to listen to that case without that predisposition, without those opinions, to leave those. I think part of education enables us to ensure that unconscious bias, that we're guarding against that, because I think that's where we certainly don't want to be led in a particular direction because we're being unconsciously directed in a particular way because of our background or belief. I think if it gets to the point where you feel that you can't be impartial, and there are cases where that can occur for a variety of different reasons, then I think it's the duty of the trial judge to recuse themselves from that particular case, or not to hear it, to have someone else hear that case.
Just one more question. Is there a backlash from recusal? Like, what is the backlash?
I don't think there's a backlash. I think that if there's a situation where, and I'll give you an example, where I used to sit in a smaller location, and there are occasions where you would know the people that are coming before the court, and you would know them to the extent where you would feel that if the community knew that relationship of that person to the judge, that they would think that that judge may be susceptible to some form of either predisposition or bias because of that relationship. So if I declare that I think it would be inappropriate for me to hear that case, I think that the public would welcome that, and that an impartial judge would come in and hear that case. So I don't think there's backlash in the way in which you've posed that question.
So my name's Liam from Sutherland Secondary, and my question was, you guys have all been through law school, been lawyers yourselves, and now you're judges. And for my benefit and the benefit of anybody who's looking at going into law school, what are some behaviors, attitudes, and characteristics that differentiate a good lawyer, in your opinion, from a great lawyer?
Well, I thought I was going to be a good lawyer from a bad lawyer, but you've phrased it in the kindest way possible, the distinction between a good lawyer and a great lawyer.
Let me just take a short stab, and my colleagues here will take another short stab. First of all, a really great lawyer is somebody who works really hard and knows their cases inside out. That is absolutely number one. Number two, they have to kind of know what they're doing. And number three, I think they have to know people. And I include that because I think it's very important as you get into the stage of your life that you engage with each other, you talk with people that you meet, you actually talk to them, you look at them, you learn how to read faces, you learn how to read posture. You don't just learn how to read words on a screen, but you actually learn what people are, and the really great lawyers know people.
Just in the interest of getting through all the questions, I'll come back to you guys on this at the end. But so I'll ask the other two judges about your question at the end. But thank you very much.
Thank you.
And next question, please.
Hello, my name is Samuel Peters from Sutherland Secondary. My question is, how does a typical court case dealing with domestic abuse play out?
So that's a big, I mean, just in terms of the long process, but is there anything in particular about that you're curious about?
Well, to get into kind of a personal, like I feel like most of us have experienced, or know people who have experienced domestic abuse, and for me, they've reached out and never really gotten the results that they've wanted, whether they've experienced it or not. The court never really has a full answer for them. So yeah, I'm just wondering what the answer to that would be.
And is this in terms of trying to get protection against somebody who's a threat to them? Or
Indeed, yeah.
Yeah.
Primarily females in the household.
Okay, all right, thank you. Again, this, I mean, a lot of this is on the policing end of things, but in terms of, I don't know, in terms of your, in terms of the role that the courts can play of protecting someone who feels that they're under threat from a domestic partner.
Well, I think there's different elements to the question and different responses. What I would say from a general point of view, I think that if you look over the last few years, there's been a greater attempt in crafting of sentences to approach the matter in a more problem-solving way and to bring resources into the sentencings that are imposed. Because we recognize that otherwise sentencing is a pretty blunt instrument. So a couple of examples. There are domestic violence courts specifically set up now where there are great sensitivity to the issues that need to be addressed to ensure that the appropriate protections are put in place, and also enabling some form of rehabilitation by way of counseling and other strategies to get to what is ultimately the cause of the issue. Now, it's not always successful, but there are several examples in BC where there are what are called domestic violence courts. I think the other piece is that the courts could coordinate between the different jurisdictions within its own court a little better. So what I mean by that is, often you have a criminal proceeding arising out of a domestic incident, and you also have a family relations matter or hearing. And I think better coordination of the orders to ensure that there's some consistency and not creating conflict by different court orders from different parts of the same process. So while dealing with the criminal matter, also enabling the family matter to proceed and not creating inconsistent orders there.
That's good.
And then, I mean, that's with a trial. Then, of course, there's the sort of urgent, emotional, and potentially dangerous situation where someone, you know, says they're being attacked and there hasn't even been a trial yet. And then how do you deal with those allegations under those kind of high-pressure situations?
And I think that there is expedited processes, certainly in the trial courts, to get matters quickly before court to get the appropriate order in place. Whether that be through the criminal process, which usually would come through initially the provincial court, or through a family proceeding, if there was no criminal proceeding, to create some stability in the short term to prevent the type of situation you've just described.
All right, thank you very much.
Great, thank you so much.
Hi, I'm Vanessa and I go to North Delta Secondary. How do you feel when the government makes changes to laws, for example, adding mandatory minimum sentences or making changes to laws that are controversial such as physician-assisted death and the legalization of marijuana?
You try that one.
In a minute?
Yes, in a minute.
I think certainly I'll speak for myself. I don't purport to speak for other judges. I'm not afraid of changes in the law. I think that's the job of the government, is to make the changes in the law to reflect the current interests and values of society. I think, as I said earlier, when it came to minimum sentencing, there were a lot of judges who felt that took away what we're supposed to be doing. And if you've taken civics, you know there are 3 branches of government. We're the judicial branch, and we're jealous about protecting our turf, and the other branches of government don't like us interfering, and we're accused sometimes of legislating by judgments. But I think we have to accept, for the most part, that if the government of the day has chosen to make a change in the law, that we're to enforce the law unless there's something wrong with the law and it's challenged effectively.
All right, thank you very much. Next question, please.
Hi, my name is Loveline, and I'm from North Delta as well. And so considering the number of criminal cases that have been dismissed recently due to long delays in getting to trial, my question is, how do you balance the rights of individuals charged with criminal offenses against the need for public safety?
So repeat the part of the question again.
How do you balance the rights of individuals charged with criminal offenses against the need for public safety?
And so this is in terms of the delay issue,
yeah,
right?
the delay of trials, yeah.
So I mean, I think one of the things about the delay issue, which I've certainly heard people talk about, is to allow someone to walk away without a trial because the delay has been so long. Of course, we don't know if that person is guilty or not, but to let them walk away because of the delays frustrates some people. You know, why didn't that case go to trial? And that doesn't seem to be the right remedy in some people's minds.
Well, the delay, first of all, it's not any delay. It's delay that can be laid at the doorstep of the Crown or the courts. So if a criminally accused person is dragging their heels and preventing their case from going ahead, that kind of delay doesn't count. But under the Charter of Rights and Freedoms, people are entitled to a speedy trial within a reasonable period of time. That's a guarantee we all have. And the thinking, I believe, is that it's better, it's always been said, better that 9 guilty men go free than that 1 innocent man be convicted. And delays tend to jeopardize the right to a fair trial. So the government have guaranteed that you will have a right to a reasonably speedy trial, and that right is going to trump the greater right of public safety in many instances. But it's that's a decision that was made by government, and the courts enforce it.
And that's a perfect place for us here on the podium to end. Thank you very much.